Welcome to Tomkins Talks. I'm recording this on the morning of Friday the 25th of March 2022. Yesterday was a rather momentous day in the world of property litigation as the Commercial Rent Coronavirus Act became law. For the last 2 years, landlords who have been pursuing tenants for unpaid rent under business tenancies have had their usual remedies curtailed, as they've not been able to forfeit leases, levy commercial rent arrears recovery, or issue winding up petitions. This all changed with the coming into law of the Act yesterday. So what I wanted to do was record this quick video and tell you 3 key things I think you need to know about the Act. So let's get started with number 1. So the first point to note is that landlords will continue to be restricted from taking action in what is known as protected debt. So that of course leads on to the question, what is protected debt? In short, it's arrears of rent, service charge or insurance rent, including any interest that's accrued on those sums, relating to periods where business tenants were forced to close their premises or operate with restrictions due to the pandemic. The code of practice that was issued with the bill includes a useful timeline showing the relevant periods for different types of businesses. As shown on the chart, the restrictions in England commenced on the 21st of March 2020. With garden centres, their restrictions ended on the 13th of May of that year. For non-essential retail and leisure, the restrictions ran through to the 12th of April 2021, and for hospitality and nightclubs, they lasted until the 18th of July 2021. When there is protected debt, a landlord remains unable to forfeit, levy CRA, or seek to wind up tenants in respect of that protected debt for a minimum period of 6 months. If landlords issue court proceedings in respect of that protected debt, then the court should stay those proceedings. Let's move on to key point number 2. Landlords' remedies in respect of unprotected rent are to recommence. So landlords will be able to forfeit leases, levy CRA, or wind tenants up in respect of the non-payment of unprotected rent. To give you a practical example of how things might apply, imagine a landlord is considering forfeiting its tenant's lease of retail premises where the tenant failed to pay the rent for the quarter due in March 2020, but also failed to pay the rent for the quarter due in December 2021. The March 2020 arrears would be protected and the landlord would not be able to forfeit in respect of those arrears. However, the December 2021 arrears would be unprotected, and once the relevant period under the lease has passed, the landlord would be able to forfeit in respect of those arrears. However, the landlord needs to beware of waiver, and that brings me on to key point number 3. One of the law changes back in 2020 was that a landlord could not waive its right to forfeit in respect of unpaid rent unless it expressly did so in writing. This has now changed back to the old position, so a landlord can waive its right to forfeit other than by express waiver. So the demand or acceptance of rent on or after the 26th of March may well waive a landlord's right to forfeit in respect of unprotected rent. So if a landlord intends to forfeit a lease for non-payment of, let's say, the December 2021 quarter, but a tenant makes a payment on the 26th of March, that acceptance of that payment may well waive the landlord's right to forfeit. So if landlords are considering forfeiting, they will be well advised to put rent stops on their account. So those are 3 key things to be aware of from the Act, but I've barely scratched the surface. There's a new arbitration scheme in respect of protected debt that I'm going to talk about on another Tomkins Talks soon, so watch this space. I hope you found this useful. If you have, please like, comment or share the video. Please feel free to get in touch with any questions, and I'll see you again soon for another Tomkins Talks.